Thanks for the introduction. This is a very timely topic for this day and age, right? Uh, so there are two trends that are happening at this point of time. So there is one trend wherein there is technology trend around IoTs, big data, right? And global business models adopted by companies, which is resulting a flow of data across borders, right? So there is literally a maze of data that's flowing across from one geography to the other, right? And trade is obviously dependent on a free flow of data. So that's one trend that's happening. At the same time, there's another trend that's happening around data privacy. Okay, so there are privacy laws coming up globally. Based on one of the studies, 71% of countries have been covered by privacy laws. Okay, till now, and 10% more countries will be covered by privacy laws very soon. Based on one Gartner report, 5 billion of people in the globe, right, are currently covered by privacy laws. Now, one of the key requirements within privacy laws is to ensure that privacy data, personal data of citizens, right, of whichever jurisdiction is protected, right, even if the data moves across borders. So hence, there are requirements of which privacy laws put in place around data moving outside their particular jurisdiction. Okay, so hence, to ensure that data moves out, and because each privacy law is different than the other, how do we ensure that from a trade perspective, global data flows happen, and for that, interoperability between privacy laws, right, becomes important. Okay, so that's the broad crux of what we are going to discuss today. And we have Rajesh, Gowthaman, as well as Shefali, right, who will bring the industry perspective as well as a specialist perspective, okay, so that everyone gets a sense of what is this issue currently that's happening, okay. To start with, right, we have the term interoperability. What does it really mean from a privacy context, okay? So that's something that let's try and understand. I'll start with Rajesh as to how do you define interoperability, and what are some of the models currently in place in the industry to ensure interoperability?
Thank you, Sandeep. See, if you go back to the basically how the legal regime evolved, and specifically interoperability, where personal data processing as part of the trade across countries, it evolved mostly from the 1981, the Convention 108, because that was the first time you had a group of countries coming together, ratifying a kind of a treaty, and making sure to see to that there is a personal data transfers that can have a free flow without any borders, as the internet revolution was already on its peak. So in light of that, and that's where we all celebrate the Global Data Privacy Day on Jan, because the Convention 108 was signed on that particular day. So now, even though the agreement existed, but there were certain cultural aspects that resulted with legislations putting certain additional requirements to see if such data has to get transferred, what should be the different models that can be adopted. Many times this data transfers also has an interdependability as well as variation from data localization concepts, because people think data localization and data transfers are one and the same, which is typically not the case. So the models that EU directive came up with, which later now we see adopted in GDPR and many other organizations, laws, is the adequacy is one of the requirements. So when you talk about adequacy, there was a very clear expectations that for a country to be identified outside of a European region as equivalent to the laws of Europe, and there were a long 2 to 3 years of strategy of a lot of discussions that keeps going on. And based on those discussions, certain countries gets identified as an adequate country, which expects that when the data is transferred to a destination country, the rights that are given by the originating country continues to extend the same manner even in the destination country. But many times this gets bypassed, and people look at from more from a checklist kind of scenario. And everybody, we had to have somebody like Max Krims to come up and remind you about what is data transfers. So adequacy is one of the kind requirement. Now, in addition to adequacy, there were two other major requirements of models that was also considered. One is the binding corporate rules, which allows not to a country, but to a specific entity or a group of entity which files and gets certified to follow certain bylaw of rules related to cross-border data transfers. Such entities gets that certification, so whereby any such group entity which is within that certified scope automatically qualifies where a data can go in. So, however, there were certain challenges. It extends only to the entity which is applying for it, not to the extended enterprises like vendors. So if you have to move to an extended enterprises, you need to look at any other model. And that's where the most 95% of the organizations around the world choose the third model, which is called as the standard contractual clauses or the European model contractual clauses. And now post GDPR, we also see many countries like New Zealand, the Popea, which is South Africa, LGPD is issuing a standard template. The changing paradigm is China, which was a local regime, moved into this kind of a regime with introducing administrative assessment procedures where a certain threshold was set up. Until then, you can use the SEC as a model. Rest, it has to get certified from the CAC, which is the Cyber Administration of China for us. So these are the three major models, and there are certain derogatory models which are consent and other things, which are widely used by organizations, but most preferable today is the European contractual clauses model.
So just to summarize, right, for data, personal data to move out of Europe to any other country, there is a white list of countries which has been developed by the European Commission based on those countries providing adequate level of protection. Okay, so adequacy is the first. The second is binding corporate rules, and mainly this is for MNCs, right, which have one office in Europe and maybe a few others across the world. So they can use, so it's like a contractual safeguard which only MNCs can use for transferring data from one entity to the other. So that's one way the free flow of data happens. And the third one, as Rajesh pointed out, is standard contractual clauses, which has been developed by the European Commission, which needs to be part of the agreements for any data that needs to move out. So these are three ways in which data can move out of Europe, and similar safeguards, adequacy, standard contractual clauses has been adopted by other geographies as well. Okay, so these are broadly the three templates. Okay, thanks, Rajesh. So I also wanted to then go to Gowthaman and ask him about what are his views, or how does he look at interoperability.
Thank you. So I just want to give it as two use cases to bring it to life, to just contrast this. Okay, as a consumer, we are all logging in to use a popular social media platform. So we log in India. I'm an Indian resident. So I log into, let's say, Facebook. I go to France next week. I log into Facebook there as well because I have my login. And I tweet or post some comments from there. Regulations say that I'm an Indian resident, so I'm protected by the sovereign country where I belong to. So even though I'm sitting in any other country, my data still has to be controlled under the control of the residency where I belong. So interoperability in that perspective is the responsibility of the platform to comply to the law of the land in which you belong to, and they have to control that. That is one challenge which they currently still face today, because it's still not yet sorted out. That what happens if my data is being abused in another country? Will the government of India go to the other country and protect my data or not? Not yet sorted out. Okay, that is one factor. Another factor, let's say, is I am a member of a leading coffee food chain in India. I have a loyalty card, and because I buy coffee with that food chain, I got Hajar points with me, which I redeem for many other stuff. So I go to another country of the same food chain. They will not even recognize your loyalty points because they will say this is not given in this country. These points belong to the country of a residence. Very different from the social media platform. I could log in from another platform, right? So some of the countries are now the MNCs who run multiple food chains in different countries are trying to see if the loyalty programs can be redeemed in another country for another as well. That is another facet of interoperability we are trying to sort it out today. In both the cases, in my view, is the law of the land prevails, which is where we are still not yet sorted out because apart from GDPR, even in the US, we still don't have the laws beyond California. So we are in that space of, what should I say, a gray area where regulations are still not under control from a common man's point of view. From a technological point of view, transfer of data is sorted out. And there are some taxonomies that's being put in place. But for the common man, we still don't have answers. That's my point of view. Yeah.
Thanks, Gowthaman. Shefali, you have experience across industries and have been exposed to interoperability at a different level, right? So, wanted your views on the same topic as well.
So interoperability, I feel, has, as he gave two fabulous examples, also has an impact on us directly, right? Let's take the example where right now, as we speak, the government of India is trying to create a unified healthcare database. All of us as individuals are going to have our database in that. So if you, for example, ever gone to a registered hospital, chances are your data is going to be there. If you have a health insurance policy, chances are the digital records are available. And this is going to be available in a unified format to anybody in the healthcare ecosystem. Now, I, as Shefali, Sonpar, know my data is available there. And how will that impact me when the ecosystem gets into play? So the ecosystem of a healthcare, for example, is your hospitals, sometimes called the provider of the caretaking, the customer or the patient. So for the payer, it becomes a customer. For the hospital, you're a patient. The clinics, the pharmacies who are giving you medicines, and some post-medical caretaker system also. So if you have physiotherapy or something, all these get connected in the larger vision. And so the data sitting in my health insurance record and the historic information there is available to all hospitals, possibly to pharmacies. And how do I control as an individual what data is available to who, to what extent? How is my privacy going to be managed? Because I don't want everybody to know my medical issues, certainly. How do we control that? And norms around that are something I believe is very important. And I'll talk about that as we move ahead, Sandeep, on the governance mechanism. So in one of my previous roles, I was the head of the data governance for AIG Global, and we created a framework to control that as how the data can get transferred, not only globally, but regionally and in the ecosystem. So I will try and touch upon that as we move ahead.
You can talk about it now itself. Why don't you elaborate on that?
Okay, so data governance is a very interesting topic. Again, very nascent and evolving. I think the regulators also now, at least in the financial services industries, have said that it is now going to become a mandatory for banking and financial services. What does that mean? It means that the way we handle our organizations as an insurance company, as a banking company, how we handle and store our data, and how is it going to be made available to the larger ecosystem? Because today, most industries, be it a e-commerce like an Amazon, be it a healthcare like I gave an example, take anything, PVR, which is into media and communication, every industry works in the ecosystem platform. Very few industries, within my knowledge, work individually. And so data has to be, or knowledge has to be transferred between them. How is that data used? So there is a data governance framework that is suggested, which includes all the way from standards that need to be followed. the terminologies or taxonomies that need to be followed, the way the data is ported, the APIs and the formats that are used. These are all prescribed. It needs to be adhered, and there are data maturity models that exist. And for those who are CMMI experts over here, it is very close to the CMI model. It becomes easy to kind of learn from there. And you actually go up the value chain of the maturity model. So if you're, for example, at maturity 1, you have isolated data, completely fragmented from the larger ecosystem, even in your organization. The date formats, the nomenclature, alphanumeric formats are unique. So it's literally 1980 standard, right? Then you standardize your data, possibly. So there are 5 standards, and I don't want to bore all of you in that, for those who are not interested, but if you become the data standard 5, it means your whole organization beyond the geographic borders use the same critical data elements. The definition of those critical data elements are commonly understood. The reporting formats are commonly understood. The KPIs are uniformly applied. And availability of data is equally there. And that is what creates a data maturity model, which allows interportability. So tomorrow, if 2 organizations come out and say, give me all your customer data, just it's a weird example, but what is the definition of customer? For somebody, it's a paying customer. So somebody could be a consumer is also a customer. A vendor could be a kind of customer. So what is the definition of customer for different people? You go to that nomenclature, and you're clear about the taxonomy of it. At the company level, at the industry level, at the country level, and then at the ecosystem level. And we are moving towards that at this point. Mostly it's happening at the country level with mature organizations. Like I said, for AIG, we actually built the complete model, and many countries are now at the common maturity level. But it's an education, and it's an evolving process. But the tighter the governance is, the faster you're able to achieve this interportability and security, which most governments are concerned about.
Thanks, Shefali. So I think we got an all-round view from what is interoperability. So from an organization's perspective, how does data move from one country to the other? What are the models followed? Plus examples from a customer side from Gowthaman, as well as how does data governance kind of relate to it, right? So data governance and data privacy are very aligned fields, and you'll see a lot of synergies as you go forward, right? Because one of the key aspects of implementing privacy in your organization is having visibility to the personal data, right? And for that, having a strong data governance program is a must. Yeah. I just want to move to Rajesh to understand from an organization's perspective, right? What are the challenges that you face when you are in a situation wherein your data is moving from multiple countries, and there's bi-directional flow of data, and each country has a different privacy law, right? So, and you would be exposed to multiple privacy regimes at the same time. So what are the challenges that you face, and what are the solutions that organizations have followed in this scenario?
Thanks. See, when we look at today, with the advent of a lot of technology, something like big data, IoT, and the most important thing is the storage size. I mean, we were talking about floppies, and now we are talking about terabytes and petabytes and zettabytes. So there is a lot of accumulation of data that happens. And as an organization which has multi-presence, the data where it is stored in lakes are not visible, because there are certain decentralized section of the people utilizing the data, and there is a centralized section who is looking at from a managemental strategy to make decision makings, right? So now there is a whole set of processes, as Shefali said. There is as part of a data governance, you try to identify these data lakes, try to create a structure, and post creating the structure, you try to classify the data, and based on the classification, you try to use the data modeling models to see how to what extent the data can be retained. At the same time, meet compliance from privacy in terms There are other requirements like deletion, which is today one of the area where we are not able to achieve a closer perfection to it. I mean, that's why when GDPR came in and blockchain also came in, deletion was one of the concepts where GDPR failed to meet the requirements of such evolving technologies. And so now data being in different pockets, using different tools, centralizing it and making sure that that data comes in a different manner, which also includes personal as well as sensitive personal data. The cultural shift in the way how organizations in much, like for example, you look at Nordic countries. Nordic countries, culturally, the privacy practices are very different. Okay, and for them, there is not too much of data usage or collection is essential for them. Even for example, if people are applying for a job, they don't collect anything beyond, they don't even ask for reference because they work on certain trust factors. You go and say to them that we need to do a background check, a criminal background check, they will just say that, sorry, not interested. But that's the cultural ambit which you look at from some Nordic countries. And when you come down in the US, to the other side, US till date, security was the concept by which privacy was trying to be adhered to. But I think post GDPR, that shift is changing, not just with California, but as on today, in addition to California, we have 11 states who have confirmed and passed. Recently, the Oregon and Delaware had passed the comprehensive legislation across. So I think even though it is not to the meeting the requirement of California, but I think with rights like data subject rights, which have been infused in all these, I think it is coming to that extent of a comprehensive model. US was always considered to be a sectoral model, but now I think it is also slowly approaching the comprehensive model. But I think it would still take some more time for them to get into the evolving concept of how personal data is treated in Europe, which is most equal to a human right perspective. Whereas, because everybody knows the history, the Jews and the data, how it was misused in Dutch, and that's the history from where the entire Europeans evolved personal data as a human right equivalent. So I think when these challenges happens, the biggest challenge that we have is it's not structured databases models where we have data. We have data in unstructured formats, which is not into visibility, which doesn't come to the visibility while you even do that kind of identification. Now, where are they stored? I mean, are they stored in a central environment or is it stored on each individual local hard disk? So I think these are some of the challenge because that's a way in which some cultural habit people work. I mean, today, if you look at in India, when a profile you get it, profile is available, the person will have to look at the profile and schedule an interview and stick. But what happens, the profile is sent by the recruiter to the concerned project manager. The project manager further percolates it to the another two people, and these two people further percolates, you take the interview. Now feedbacks, everything comes into the picture. But we do tell there's a requirement that after the purpose is over, say example, we have not selected the candidate. My purpose is over. For me to keep that resume or any interview feedback for a 10 to 20 years is not in line with the laws, right? So these aspects of data, when it happens, complying with some of the rights, as I was mentioning, like right to erasure or right to be forgotten, becomes a very positive challenge, and that is going to impact organization. So data governance, the interoperability, bringing it all aligned as to meet the requirements of privacy and keeping in mind the safeguards that the security has to add to it to make sure that it is probably achievable. So I think that's the whole gamut of the play.
Just one question here. Based on your experience, how well are organizations aware, or how much visibility do they have in terms of where is the data moving, which countries is it going to, and how are the flows happening globally, right? So because there's a huge supply chain which connects one country to the other, and there are onward transfers. So how does an organization manage that currently?
So to be truthful, from my perspective, and not to the where I work right now. So, but it's from a truth perspective, every organization today runs and tries to meet, achieve a compliance based on a risk-based model. right? So let us, I think it's an industry practice. It is also understood. When we had such a requirement like Scrums 2, and Scrums 2 recommendations came in, the recommendations were, before the preliminary draft, had a very stringent requirement. But when you look at the final recommendations that came in 2021 June, you will see that as long as the organization is able to take a risk-based approach in determining the necessary supplemental measures are put in place, then it is assumed to consider to meet with the compliance of the requirement, because it's understood. I mean, we had Screms 1, it was hit off, then after a decade, Screms 2 came in, now the DPF framework has come in. Again, I hope we are expecting another Screms 3 to come into picture. So hopefully the journey goes around. But I think organizations are going because, see, it's a trade. Many of these are also political issues. So I think all these gamuts make the face to have a risk-based approach as a right model, as long as we take the necessary precautions and we make sure that we are compliant to the achievable where it is all documented. The visibility part, yes, through different sophisticated tools like discovery tools, you will be able to identify it. But taking a decision and sustaining it is going to be the challenging part. You know, specifically with the attrition and other things that is happening, you can't have a very localized process to control a user, because today the user doesn't feel compliance is part of their perspective. If they feel compliance, it should be done by a central team, not belonging to them, because it's not part of the KRA, right? So I'm sure these cultural ambit will play definitely a role, and it's a risk-based approach is the right model to proceed further on that.
Thanks. I'll pass the question to Gowthaman and on the challenges and how organizations are trying to overcome it, but also want your views on a topic which is very close to the ad industry, right? Around consent. Consent being the main grounds for collecting and processing users' data. So how, and one of the challenges is you need to ask consent for all very granular purposes, right? And this will lead to consent fatigue, right? So, and different organizations need consent for maybe mainly similar purposes from the same individual. So, wanted your view on what kind of challenges and solutions are emerging from the industry around this.
It's probably the most complicated one that is in front of the industry to solve. I'll give you a very practical example. You go to any movie theater hall here, I order a popcorn, and that guy asks for my phone number. I give it. We don't talk about consent at the time because I have to rush to the theater. I order a popcorn and say, sir, phone number, please. I give the number, and I don't know what he is using this for. And for all practical purposes, he'll probably send me a message or a bill. But that's what I'm trying to say. Practically securing consent is a challenge today. But at the same time, the regulations say that every time a consent is being used, that company has to maintain a record of what you have done with that processing. And consents are being session-based. It's not that I secured consent once and forever I can chase him to death, right? So consent management framework is something which the industry companies are trying to find a way in which they can address it. It's a nightmare in the way I see it. It is also a function of educating the consumers to really opt in or opt out of consent. Regulations are differing across the world. Certain countries are opt-in consent.
If you can explain, because the audience may not know what opt-in is.
Certain countries are opt-out consent, which essentially means that every time I opt in to let the enterprise use my data, so I'm opting in by default. Opt-out it is considered as not used, and for that particular session, I give them permission, right? That has got huge implications on regulatory maintenance of data, because the common theme from all regulations is the company should maintain a record of what they have done with your data. The heart of the problem is that. But that is not solved by multiple consent frameworks that is available today. And that is a challenge, Sandeep. So I don't think we have solved it out yet. But I mean, the classic example is the popcorn example. I mean, you go to any other country, they won't even give the number. You go to Germany, they'll say, why are you asking me the number? I mean, it's like dangerous thing. It's like asking your horoscope.
Yeah.
Here we give the number right away. So it's a problem. I don't know how to solve it.
Okay. Thanks, Gowthaman. So, Shefali, from an interoperability perspective, right, the concept being used in other areas as well. So, what kind of solutions have emerged in other non-privacy related areas around this topic?
Can you, can you repeat the question?
Interoperability, right, is not just something which is in the privacy domain, right? It's there are these challenges are there outside as well, right? Banking, etc. So, what kind of solutions have emerged which promotes interoperability?
I think, sorry, I didn't understand the question. So, I'll go back to my ecosystem point of view. When, for example, we took the example of PVR you mentioned, and it's such a basic example. When we use Paytm, for example, right, all of us are giving our mobile numbers to make the digital payments. A lot of that data is being used, again, in the ecosystem of it. So the vendor receives it, an advertiser receives it, possibly a cross-seller receives it. Obviously, Paytm receives it. Paytm holds the rights to cross-sell with insurance and all other things. They have an internal Instamart, I'm not sure what it's called, but internal mart that they have. Now, how is this my data and my mobile number, and all I've given him is my mobile number, that's all, right? And of course, my KYC. He has enough information to churn it to generate revenue. Have I given that consent to do it? Somewhere in the subtext and subline I did. But how much of it have they misused or used it for their benefit versus my benefit becomes the way in. I again go back to my example earlier where the government is trying to create unified databases for individual records. We now have the Aadhaar. We all individually also know how concerned we were with having Aadhaar as our centralized database. We equated to our SSN numbers in US. But here's the truth. How cautious SSN, when somebody in America is asked for SSN, they hide the first 5 digits or 6 digits and give only the last 4 digits. Even if somebody says, tell me your SSN, you're cautious. Right now, I can ask one of you, and out of trust, you'll give me your Aadhaar number. I was giving an example just before this. I know I'm drifting from the point, but a few nights ago, morning I got up and I saw my mail, and I had about 12 emails. 331, 332, 333, 334, 335, 12 messages saying Aadhaar authentication failed. Which means somebody in the middle of the night at 3 o'clock at night, where I was in deep sleep certainly, was trying to use my Aadhaar. Thank God the two-factor authentication or whatever Aadhaar verification failed, and I got that notification. But I have no way of finding out why it happened, who was trying to do it. There is no trace. I tried to go to the website, no idea. And that is not the kind of security I want on my data. Now, tomorrow you are going to create my healthcare database. You already have a central database. All of us are filing our ITRs right now. The government of India has a centralized IT database. A lot of hackers are there that are trying to reach out to the centralized database and use it. But at the same time, can we stop creating this? Because that is just how the fuel of tomorrow is going to be. If I don't create ecosystems, my ability to service individual needs becomes limited. So it's a very delicate balance of how you create solutions, and each industry has to come out with its own solution. The government can act as a nudge, but every industry has to come out with a unified solution. The financial services industry has to come out with a unified solution because the nature of problem is different.
Sure.
The nature of problem in healthcare is very unique. The nature of problem in, for example, transportation is very unique. I don't know how many of you know about this, but the Indian Railways database was hacked recently. How many of you have traveled by train? So that's something that we need to be aware about. How is that data being used, and to what extent are you giving your data away for people to possibly hack in or consciously use it for reasons we don't know?
Thanks. Yes.
On the consent, I think we are having some new concepts of consent manager. It's something equivalent to like an escrow agent, right? I think there are aggregating things that's happening where you have, and this is also, I think, the PDPP bill is also promoting it so that companies can come into existence, gets identified, registered, who can manage the data centrally, and depending on the consent promoted or provided by the data set. Because see, consent has its own norms. So, because the law doesn't bother about it is X entity or the user or the Y entity. It's basically talks about data subject. It's an individual. It's their prerogative not to be interfered with, and not to be disturbed. And they have a choice. And every time when a consent has to be given, it's a choice that they should be able to promote. If you really wanted to talk in the true spirit of what privacy really means, that's especially the requirements that needs to be achieved, where certain regions make consent as the only promoting. Now, consent has two norms. So we also talk about transfer. One, you collect the data for a processing, you need a consent, if you use consent as a basis. Then one of the processing would involve transfer, that is another. So in both these cases, consent as a lawful basis has to match. We can't just say just I consented to take and people have given, doesn't mean that I can directly go and transfer the data. So this is sometimes because even in legitimate interest, everybody goes for legitimate interest. If you are collecting special data, which is the sensitive data, you can't use legitimate interest as your lawful basis. Because that's only way for you to do is consent as the basis. And while doing that, there's a huge challenge because you need to test, even if it is legitimate interest, you need to test the two major standard principles, which is the necessity principle and the proportionality principle. And this is very essential. And if you go back and retrace the steps of SCRIMS 1 and SCRIMS 2, you will feel that, you will definitely see that this was the basis why such a kind of approach between EU and US was struck as unconstitutional twice. So I think that's the basic I want to call. And consent manager is able to take care of some requirement, but it is in the very initial gestation stage. We should see a lot of developments around that region.
So Rajesh, for the audience, right, if you can elaborate on who or what a consent manager is, right? They may not be familiar with the term.
So right now, consent manager is basically just like an escrow, right? I mean, today what you do is you take an escrow, identify a law firm of somebody to maintain an intellectual property, and then probably there are possible buyers who would like to test it based on certain conditional requirements to submit. There's an amount, so then you release it based on the requirements. So a similar way, consent manager is probably there's an entity which will be set up, which will have the entire base data. Now tomorrow, if suppose Amazon wants to use it, and if then what happens here is Amazon says that I need the following data. So the consent manager goes back on a systems to see whether there was a consent provided by the consumers to allow that data to be transferred. Similarly, the same data which is there, if another entity is asking it, whether that has been provided. So there is a choice for the individuals to decide that I would like to give the data to this, but not for this particular entity. I think the choice, and that is what is the consent management, so building a solution. But the challenge that we potentially see is now anything goes wrong with the data, who is going to take the liability? And the liability more from a security standpoint, because everything is, if that single point of failure where there is one particular entity alone, that's why government has to promote many such, as a business where many such entities can come into the market to set up this consent manager portal. Yeah.
So from a data governance point of view, what you're saying, and the terminologies can vary, and I guess we need a standardization there also, but we call this access management, so data access management. So there has to be a fairly clear hierarchy of data access management, and both in terms of access levels and access depth. So at an individual level, customer data can be accessed by who, and there is, so it's actually a fairly complex grid and governance that we built. So there are third parties, internal parties, user parties, and then there is extent of data available. A very simplified version for all of us, which we can relate to, is our payroll data, right? Payroll data should ideally not be available to everybody in the organization, one. So no access available, general access, zero. Second, can everybody in HR have access to it? No. Only a compensation manager, even in that level of hierarchy, only compensation manager and potentially your direct manager. Beyond, so that's your depth and height of access. To say that HR data hai, HR ko lene do is where things go wrong. Marketing data hai, marketing ko handle karne do is where things go wrong, right? So access management is a very, very strong domain itself, which needs a lot of due diligence. A lot of regulatory compliances happen and issues happen because of access management. It's a subdivision of governance in itself, which controls that and is regulated as to how, especially in India, it's not so prevalent, but definitely Europe with GDPR, etc., has become extremely difficult to navigate. We used to actually, when we did a report for the chief HRO of one company, for his department, his geography, everything, we actually created a closed room where only 4 people worked on that report. And the laptops were unique, and after that was done, we actually purged the laptop completely, so that the personal data of that, and it was my team, I didn't see it. Only those 5 people could see it. And we deleted the whole folder, which was in a shared drive, and then only the project was deemed closed. So to that extent, they take care of it, that even as an IT team, if we are creating reports, and because we were doing the data governance work for them, access control work for them, only those 5 people were allowed to see it. And as a department head, I did not have access to it.
Thanks, Shefali. I think one final round of, we'll come to Q&A. We'll just finish this round. When we look at interoperability and data moving from one regime to the other, right? There are a lot of steps which are happening at a government level, right? Wherein government is coming up with a white list of countries where data can go to, right? So there are a lot of work happening at a government level, but are there things that an organization can do to promote interoperability here?
Yes. If you look at, I think everybody knows GDPR because that has shaken the boards, and we would have used that as a regime to meet both privacy and security related domains, budgets and other asks. So if you look at GDPR, there's this concept called as a code of conduct, right? So the code of conduct is something where you can have either certain industry, like for example, advertising bureau, International Advertising Bureau has come up with a code of conduct where the advertising businesses in terms of handling personal data can be managed. And I think that's basically the group global privacy control is a concept that they evolved in to see to that from an advertising concepts to meet any online related, how you can adhere to a compliance. So similar like that, organizations can come up and it can be placed before that local authority for their review, which can be not only accepted by that local authority, but also by other authorities as part of consultation process. So yes, as a maturity setting platform, organizations can also contribute to do that and bring up a better, more wider proper solutions to achieve the expectations of global data transfer concepts can achieve.
One additional point here, what about certification mechanisms? How prevalent are they, as in how often are organizations using it?
See, certifications in general, while we are, let it be an outsourcing industry or any other industry, there is a mark for you to always showcase to the authorities wherever, not just from privacy standpoint, but to meet that you are standard and meeting compliance. So we have ISO and other things which have been very prevalent. Now this certification aspect is specifically beyond the regions where, because ISO is something which you can adopt it. Now the same aspects, you can have the local authorities define and use it as, like for example, Germany recently came up with a similar technical specification standard. It was totally in parallel to your ISO 27701. It's basically it's a political. It's a point that why to rely on somebody outside. US always relies on NIST. So similarly, China has come up with the technical specification standards as part of requirements to comply with both PIPL and DSL, the data security law. And if you look at it, it's still not been mandated. The day it gets mandated, what is currently been mandated is only some MLPS certification under Section 20 of PIPL. But beyond that, this has been set as right now as a guideline. It's very far to once the Chinese government say that, okay, if you would wanted to meet assurance to my compliant local applicable law, have the certification. So I think this is an evolving thing which industry as on today has been automatically been practicing. It's just that instead of adhering to a global, we're just going to make it localized. Sure. Localized because of the law that is demanding or the authority is demanding. Like, best example, there's much of the laws doesn't come and say that you have to appoint a data protection authority. It's only certain trivial factors. Similarly, like Singapore also did the same. But however, these countries mandated, where the commissioner mandated sending regular forms asking people to submit a name as part of the register to maintain workshops and programs. So I think it's a practice probably to have a higher vigilant of compliance practice in the future. But I think that's the way it is going to go in. So we may see some localized countries coming and mandating such tests. And that will become the certification mechanism. In that line, the certification mechanism under the Article 42 of GDPR can be seen, but I don't think many of it is in the anvil. It's the authorities who are taking lead onto those programs.
Sure. Gowthaman, any point around certifications in the
I think it's lots to be done there because there's no one consistent format or and how do you distinguish between industries and certification? That's the big challenge right now because the same company isn't a marketer, is an advertiser, is also a healthcare company. So it's yes, it's an open canvas right now. Yeah.
Sure. So broadly, what the summary that's coming up from the discussion is this is still a work in progress.
Absolutely.
And as laws emerge and I guess all the governments do want and organizations do want that free flow of data, there is, so the mechanisms how to ensure free flow of data yet ensuring that the privacy is conserved is something that we'll see a lot of work that is going to happen in this area in the near future. Yeah. We'd like to throw this open for Q&A, right? Yeah. You have. Can someone give the mic? Yeah.
First of all, thank you so much for.
Yeah. Yes. Sorry, we'll come to you. Yeah.
Thank you. See, when it comes to the consent manager, he is not possessing or is not taking the custodianship of any data. His role is only managing the consent. Who gave consent to what data, till what time, and then what purpose. That only he maintains the record of the consent, not the actual, the privilege to grant the consent. That is one thing I want to clarify. And another thing is the data transfer is highly misunderstood actually. I mean, so how much data? If I transfer 10,000 records, you will agree as a transfer, or you transfer 1 lakh record? Actually speaking, today in India, the 100% medical claim processing of US is happening from India. And this is now they say that we provided VDI and nothing comes here. My only person is logging in and seeing that data and then processing there itself, nothing been transferred. But I think every resource knows by first name, last name, everything. He went to which doctor and how many times he went, everything is available. At the end, he monthly once he submits that also. one particular patient went to which doctor for what ailment, and every data is summarized and sent in the form of Excel sheet. But they are claiming that there is no data being transferred. Okay, so this is again, this is not coming from technical control. This is the privacy manager or the privacy strategy the organization has to take, what to be visible in while processing outside the country, whether that country, still now as per the US law, this is not a safe harbor. India is not safe harbor, but still almost 90% of the data been processed in India for the medical billing.
Yeah, so data transfer, when you talk as a cross-border data transfer, whether it is a million data sets or is it just 100 data sets, it doesn't, as long as it is like a control over the data, which means, for example, this is a typical example that I give. Me as a client coming to a particular service provider to say that, see, this is my personal diary, I wanted you to gift wrap it. Now my service that I extend is, which I have been asking from the service provider, is only to gift wrap. But the way my data in the diary, which is my personal diary, may get exposed because of the lapse in the management, would result in viewing of my data. So even if a person is viewing a data, even if it is 1%, it considers to be. And in US context, as we said, security used to take predominance. That's why if you look at any of the contracting requirement, security takes so much precedence where the technical and organizational measures, when I say technical and organizational, we are talking in sense of the logical and other controls, plus at the same time the organizational controls talks about administrative measures, which is like ensuring that the person is trained effectively, person is using the data only for the purposes that have been agreed in the services that have been provided. That essentiality of at the time of onboarding has to be very much. And we have seen many cases where failure to bring that employee who is working on the project sensitized about it has resulted in a lot of penalties. We have in Singapore the Satyam case. In 2013, the Jacinta's case, where Prince Kate and William, there was 2 radio jockeys who impersonated and a nurse got fired off. And the hospital had to pay a heavy penalty for disclosing where a staff said that she's just pregnant. That's it. That statement, which was in our live streaming, resulted in huge impact. So viewing of the data is also, and that has been very clear, post GDPR, it has been made much importance. And US is still not caught up with that, but still US relies on technicality and retention of data. So if you look at any legislation across the globe, other than GDPR or GDPR-like statutes which has come in, they're primary as a service provider, these 2 principles automatically applies. Security and storage mandatorily applies. The other principles don't apply for any of these service providers. These 2 continue to apply. And I think it's just about sensitizing and awareness of the, is what is point. But just point noted, thank you.
No, I want to build on what you are saying. So basically it is being now classified as PII and non-PII, right? So the email address and the name and the phone number are classified as personally identifiable information, and every other report attributes are non-PII. Once the regulations comes into place, this will not work. The PII has to be masked. You can process the data sets of whatever you want on health records, but the PII is the one which will be encrypted for further transactions. So I think when the regulations fully fall into place, sir, that's not possible anymore. They have to be redacted. Yeah.
HIPAA already has that. HIPAA has a very strong PII rule. We may not be adhering to it, and I hope that there is nobody here from the US listening in, but you are breaching the laws if that is happening. So I'm assuming you're talking about something that potentially can happen.
Thank you. Thank you.